And welcome, everyone. Welcome to Tuesday, February 4th, 2025. If you're on the replay, who knows? But let me do a sound check and make sure you're hearing me. And it looks like we are good to go. So I want to say hello to all of you. And if you're on the replay, hello to you. Welcome to the Twilight Zone. And although I'd love to say that be prepared, you never heard anything as insane as what you're going to hear today, that would be somewhat inauthentic because today you're going to hear just about what you would expect from prosecutor Nicholas McClelland in the Delphi murders case against Richard Allen. Complete falsehoods, uh, uh, bottomless pit of gaslighting, and total ignoring of reality. And so that's what you're in store for. Today we're going to take a look at the recently dropped filing in response to the motion to correct error, which was a pretty good filing by the defense team for Richard Allen. This state's response, boy, do I have some opinions about it, and so I will be expressing those. It's just what you would expect. These people are insane, but spoiler alert. You should know that my ultimate conclusion is that although it's insane and baseless and not on any type of firmly established foundation, I am absolutely positive that the judge will go ahead and pave the way for Nicholas McClelland to get exactly what he wants and to ignore the defense's motion to correct error. Trust me, she will go right along with it. But what we'll be doing today, a little different than most people you will probably tune into regarding this particular subject matter. We will not be doing a bitching and moaning session. What we will be doing is we're going to do an A/B comparison of the motion to correct error and the state's response. So if you're in for that, stick around. If you're not, get the hell out of here. There's plenty of other things to do on YouTube regarding live streams and video content. So we'll be getting into our show. And I do look forward to the attorney's take on this particular state's response. Mostly Miss Andrea Burkhart, particularly interested in her response or her opinions, because I was pretty much completely aligned with her take on it to begin with on the defense's motion to correct error. Wherein she assumed that the appellate attorneys will basically have to go the route of ineffective assistance of counsel, which I agree with. I've told you this defense team has fucked up immensely when it comes to this case against Richard Allen. It was not all their fault. They were handicapped from the beginning in a number of ways. This was a very combative scenario. Remember, the judge tried all she could to have these attorneys removed, to shame them, to accuse them of basically negligence, etc. The prosecutor tried to have them arrested and kicked off the case. The troll farm tried their best to have them trapped and set them up with Mitch Westerman and the entire scenario regarding the leaks. That's a whole other subject that has yet to be covered and yet to be investigated by the state of Indiana, oddly enough. And we know that Andy Baldwin is calling for an investigation, and we support him on that. That those leaks need to be investigated thoroughly. And as we covered in our previous live stream, there were more than one leak. There was more than a leak from Westerman. Okay, there were many leaks, a litany of leaks that need to be investigated properly, especially the one involving the death of Mr. Kyle Fortson. It's just also sus. It's also sus. Okay. Anyhow, as we wait Miss Burkhart's commentary on this, we'll have mine. Okay, we'll have mine. We're going to take a look under the microscope with the A/B comparison, or the state's response compared to the original motion to correct error. And we're going to take a look and compare contrast and see where reality is being denied by the prosecution in this case. And we will hope that the ultimate outcome of this is that it all goes to appeals. The appeals courts on whatever level will have to make their determinations. And in the meantime, all we can do is guess. Okay. So before we get started, let me say hello to those of you who are here. I appreciate you for being here. I'm a little early tonight, but I'm going to try to do that from time to time for our viewers who are in different time zones or end up being early to bed. Okay. So we'll be doing that from time to time. So today we're a little earlier than usual, and that's for our viewers who don't do the late nights. Okay, pardon me. All right, so let's say hello to who are here. Let's see, we got Spicy Cappy, Court of Public Opinion, Miss F, Plain Iron, Rebecca Ann, 1965, Oleg Cat, Silenced, Lisa, Sunflower, Dawn Steele, M. Osland, Sweet Dude Shibby, Marianne Foster, Donnie Pitbull Kuntz, Men. We got Elizabeth Park, Jay Lynn, Four Pit Bulls of America. All right, we got Aaron M. Town for Baby Daddy, Tammy McRae, I'll Allow It, Stephanie, Heavy Metal Rehab, Marianne Foster, Scales of Injustice, Miss K. The whole crew's here tonight. 26 Dead Zombies Dude. We got Megan, Rotstar, Mimi's in the House, TJ Bits, Zoe Hamilton, Say What, Mudbug, Augie, Mino Dino, here to bully everyone. Come on, enjoy. And Mudbug is already gifted a membership. So congrats to whoever got that. Hope you get some more. Ricardo 2. We got Elizabeth Jones, K, EWTN. We got JJ Falk Jr. Welcome. We got Swade Smith, Pam Sheehan, Withall and Silenced, Asphalt Sally. All right. Who else we got in here? It's a New Day. What's up, It's a New Day? Go subscribe to It's a New Day, please. She has a wonderful content. Sarah, welcome. Bonnie, welcome. Sarah, welcome. Trial Junkie, Purple Amaryllis, Shiloh, Dirty Diana, Possum Friend, Peaches 81. All right. All right. So that looks like that's it so far. And like I said, anyone lurking, go ahead and join the crew. Anyone on the replay, leave the comments down below the damn video. Do that. You missed the live stream, too bad. Can't leave live chat, but you can leave comments down below. We appreciate those too. Mama Bear 2222. And support the channel too. Hit the Cash App, hit the Buy Me a Coffee, and the super chats and all that stuff. Support the channel. This channel needs your support. Hey, we don't beg often, but when we do, we do. So there you go. Support the channel. Appreciate that. And anyway, that's where we are. So, wow. We had a wonderful show yesterday. Really did. It was called Delphi Weight of Justice. Okay. Weight of Justice. A wonderful show. Very few people showed up for the replay. Pretty odd. Okay. We're about 1,000 views short on the replay. So who knows what happened with that algorithm. Maybe I didn't make as nice of a thumbnail. But that show yesterday was very good, I thought. And so was the one before that, and the one before that, and the one before that. So if you're new here, go ahead and go watch the one from yesterday, too, after you're done with this one. Okay, the one called Weight of Justice. Appreciate that. And anyway, everyone's coming in. Appreciate you for coming in, and we will get started because boy, this is just something else here. I called today's show Delphi Motion to Correct Error, State's Response. And I put error right on the prosecutor's hair plugged face because, boy, I've just never seen anything like this. I don't know about you. I wish we did have an attorney in here from Indiana who was a very experienced defense attorney, a trial lawyer, because I would love to have an experienced Indiana defense attorney here to comment because from the outside looking in, it looks like a dumpster fire. And so the first thing I want to do, okay, boy, this is funny. This is funny. So I'm gonna, I like to show you receipts. Those of you new here, you may not know that I'm all about receipts, pretty into them. So I want you to look at something first of all, because this is pretty interesting. Okay, pretty interesting. You can always tell. I mean, these people have been so for their efforts to cause obstacles and a lack of transparency. They're very funny because their MO is always so extremely transparent. You can see through these people like fucking thin air. I mean, it's amazing. You can always see it. First of all, they project. Okay, they project. Secondly, they respond in fear, and they gaslight. It's all the typical narcissistic abuse pattern markers that you see with these people. But I wanted to add this before we start just to get us off rolling, so that you have the right context to understand where we're going here. I would like you to see this. Let me put it up here. So check this out. Okay. So this was the motion to correct error. Notice the date. Okay. January 20th. Okay. Are we all in agreement there? January 20th. Okay. January 20th. Okay. Pay attention to that. January 20th. Got it? Good. Good. And what's today? Oh, what's today? Today is February 4. Okay, February 4. You cannot make this shit up. Okay, so where does that put us? Let's see. 7, 8, 9, 10, 11, 12. 12. So Prof, what's your point? Well, I'll tell you what. No kidding. And then, look, I'm not making a joke here. Okay. 12 days to respond. Now, what's the point of that? Well, that's about approximately half a day per page. Okay, half a day per page. Okay, what that means is, in order for Nicholas McClellan to respond to this damning motion to correct error, he had to spend approximately half a day on each page trying to pull some type of gaslight out of his ass. I mean, it means it was a struggle, because let me back you up and try to shed light on what I mean. Typically, these responses we've been seeing come within a day or two. So between 12 and 24 hours. Okay, typically. So typically when there's a response to a defense motion, it's been in a day. Like boom, next day, boom, next day, boom, next day. But this one that we're going to cover today, the state's response, took exactly 12 days. Oh my God. You know what that means? That means that it was a struggle. I guarantee you, this was, look, if you don't think that this judge was on the phone with this dumbass, okay, I guarantee you it was a struggle session. That's what it was. It was the judge, it was the Jody Williams, it was Jerry Holman, it was McClellan, and probably fucking murder shits. Okay, I guarantee you it took them a week of putting their heads together to get all their ducks in a row to figure out how to argue every single bullet point on this motion to correct error. FML, yeah, trust me. And if you think that's not happening, look, let me back you up. Judge Diener received the safekeeping request from Tobe Lesenby. Then he took it, shredded it, tore it up, threw it in the trash, wrote it himself, handed it back to Lesenby, and said, okay, now file this with me. So if you think it's above these people to collude illegally, unethically in this process, well, you're just smoking crack. You're troll farm. You're troll farm. You're either stupid or you're in on it. Okay. And look, I know we have many mentally ill watch the channel. Trust me. Ashley, okay, don't watch anymore. Michael, don't watch anymore. Tracy, don't watch anymore. Okay. This case is full of mentally ill individuals following this case. However, those in that prosecutor's office, those responsible for what we're going to read today, okay, they're not mentally ill. They're in on it. You understand? So I guarantee you 12 days to respond. This was putting our heads together, struggling for a week and a half to figure out how to respond to this. All right. So there we go. Anyway, you just can't make this shit up. You just can't make this shit up. And listen, look. This is an entire, like, I've covered it so many times. Actually, let me see what show that was that you should go watch if you don't understand this. What did I call it? I don't know. Shit. Maybe it was the Anthony Shots show in which I talked about it kind of at length, which is the PR machine. Okay. The PR machine behind this prosecutor's office in this case is unbelievable. You would never believe it. Listen, I didn't believe it. Okay. So let's hit the reset button. When I came into this case, I was an idiot. Okay. I was totally naive. I never would have imagined that this case is infested with PR agents. Okay. All of the YouTubers, all of the Redditors, all of the bitches online sending us pictures of their tits and ass, calling us on the phone. You see what I mean? On every level, this case is infested with sextortionists, gaslighting, prosecution shilling, boot licking, ass licking, bullshit, compromise, pedophile, criminal underworld maggots. And let me ask you, what kind of case involving the murder of two little girls, two children, would have that kind of contingent behind it? What are they afraid of? What on earth are they afraid of? Yeah, I mean, someone tell me, what is this prosecutor afraid of? What is this family afraid of? What is this judge afraid of? What is this Indiana State Police afraid of? That they would have 50 to 60 individuals covering up the truth about this case. I'm talking about a completely entrenched, deep PR campaign, complete with misinformation, disinformation, right? Harassment, abuse, stalking, hacking, etc. What would it take? It would take millions of dollars, or it would take some sort of consequence hanging over the heads of those who are doing their bidding. Whatever it is, there's a big team behind this. And trust me, this thing we're looking at, that we're going to look at today, I have already said, there was a team behind this effort. That's why it took 12 days. This was so difficult that it took them 12, what normally takes 12 hours, took 12 days. All right? And trust me, the PR continues. You know, now they've put David Vito out. They've already put Brian Harshman out. They've already put Jerry Holman out. They've already put Nick McClellan out. They're putting the whole contingent, the whole front line, they're having come out and do their talking points. All right? So, who comes out next? I wonder. Who are they going to bring out next to do their talking, running their mouths? So the odd thing is that the things in here already, as usual, the troll farm has been ahead of it. Okay, the troll farm has been running for about a week. Well, actually 12 days. Okay, as these talking points have been developed, the troll farm has been running with these talking points. So it's telling, right? It's telling. It's telling. They always somehow seem to know 2 weeks ahead of time about everything happening with this case. And yes, murder sheet's a part of it. Copyright strike me for using your name. Yes. Remember, anytime anything needs leaking, who do they tap? Murder sheet. Anyway, um, I guess I can stop my blah blah blah. It's time to do the work, right? Time to do it. So this is the state's response. 12 days in the making, y'all. Like I said, I guarantee you they had a little hangout. It was Judge Gall, Jerry Holman, Nick McClellan, Steve Mullen, probably Jody, probably Murder Sheet, probably Pecky Batty. Yeah. Excuse me. All right, sorry about that. I have a little virus. I haven't really advertised it, except I told Skip. Sorry, I told Skip I got a little virus. Um, so I'm a little sick. Yeah. Anyhow, yeah, we're supposed to be doing work, so let's get to it. Here we go. All right, safekeeping order. You can't make this shit up. Oh gosh. Oh man. Brandy Hughes just got her pussy booted out of here. Oh, you smelling like Badussi. Get on out of here, girl. Why are you even here? You had to spit on that thing. She's gone. She gone. Bye, girl. All right. She dirty. That's the kind that washes her ass, then washes her face. Yeah, that's the kind of girl she is. Oh yeah. Who's next? Bring it, bitch. Listen. I've already had the white nationalist fucking neo Nazis threaten to come to my house and kill me and slice my throat. You think you think you're gonna bother me as a troll in the chat? Come on, man. Look, I already got my local PD fucking patrolling the neighborhood at night, and I'm sleeping with 5 guns. Come on, man. Let's get the fuck out of here. Okay. All right. All right. Let's get started. Sorry, I had to just let it out. No, not with the same soap, with the same towel. Yeah, same towel. Okay. All right. So where were we? Oh, so check it. So check the gaslight. Check the gaslight. He starts off. He wants Judge Gull, and like I said, spoiler alert, he's gonna get what he wants. Remember, Judge Gull is the woman who is breastfeeding Nicholas McClelland, so he gets what he wants every single time. All right. So he says, "I'm asking mommy to deny this without a hearing." All right, that's how it starts. He says, I'll tell you, the defendant's motion does not warrant a motion to correct error. And what's his reasoning? Because a motion for safekeeping filed by the Carroll County Sheriff is not a critical stage of the proceedings. Okay, that's part A. And part B is the evidence concerning Brad Weber, Ron Logan, and Stacey Eldridge is not newly discovered evidence to warrant a new trial. The state would ask the court to consider the following. Okay, now let me say, I do agree with part two. Okay, so this is where all of the defense ball lickers are going to get mad at the prof, and I'm okay with that because you're a bunch of woke libtards anyway. Okay, look, I believe it's pretty true, and look, so did Andrea Burkhart, right? The evidence about Brad Weber, Ron Logan, Stacey Eldridge, it's not newly discovered. All right, it's the defense's fault for not handling it properly. So that's going to go towards appeal and ineffective assistance of counsel, most likely. Okay, those were places um, where they missed. Okay, the defense dropped the ball. But as far as the sheriff, the critical stage of the proceedings, okay, that's what's important. So look, let's do this. Because all of you are here, we might as well do this. So let's say I'm gonna ask the AI. So All right, so I'm asking the AI. So let's see what AI has to say about it. So let's say critical stage in Indiana. Jeez. Okay. Critical stages of proceedings. Okay. Critical stages of proceedings. Custodial interrogations, both before and after commencement of prosecution. Custodial interrogations, okay. Preliminary hearings prior to commencement of prosecution where potential substantial prejudice to the defendant's right inheres in the confrontation. Lineups and show ups after the commencement of prosecution. Plea negotiations and at the entry of guilty plea. Arraignments. That sounds pretty broad and it sounds open to interpretation, doesn't it? Okay. Let's see if we get another one. Can we get another one? This is it's pretty all the responses I'm getting are somewhat ambiguous as to the critical stages. Okay, for instance, this is Indiana. Okay, let's see. Oh wow. So I think that what's going to be important for us here um, is to have some opinion from knowledgeable individuals about in Indiana whether or not in this instance this would be factually a critical stage, and if it is the judge going to agree with reality, or is the judge going to deny that and to just pave the way for McClelland anyway? So let's A B this, okay? Because we know what the claim is. So let's go back and forth. And no, we're not going to talk about him, okay? First of all, I'm going to delete that uh, because I don't want to hear what he has to say either. I want an actual fucking trial attorney, not someone running their mouth, okay? Um, sorry. Let's see. Oh man. All right. There you go. There you go. Okay. I goofed. Nope. If I see his name, I'm deleting it. I'm telling you no. So I'll just sit here and delete his name until you all shut up. How about that? All right. Yeah, I'm not accepting that. Nope, nope, we're not talking about him. Nope. Okay. You guys don't even know how to control yourselves. All right. So let's look here at what McClellan says. All right. McClellan says, not a critical stage. So he says, A, defendant claims his 6th and 14th Amendments were violated. Hold on. I'm starting to get pissed off here. All right. Critical stage was violated because he was deprived of counsel at a safekeeping proceeding November 3rd, and that the proceeding was a critical stage where he was entitled to an attorney. Defendant further claims that since he did not have counsel at hearing, the conviction should be overturned. Indiana Code 3533.11.1 states that upon motion by sheriff alleging that an inmate in a county jail awaiting trial is in danger, blah, 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 blah. If the court finds the inmate is in danger of serious bodily injury or death or represents a substantial threat, the court finds that the inmate is in danger, blah, 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 it shall order the sheriff to transfer. The statute does not require the court to have a hearing to make this determination. All right, so let's pause and let's go over to the states. Okay, let's revisit it. All right, let's read here. They graciously lay out this for 11.1, and we're not going to go through it because I've shown you before. It says here, Mr. Allen was interrogated and arrested on October 26. We know that to be true. Fact, check. The next day, Kathy Allen hired an attorney. Check. On the evening of October 27th, Mr. Gibson notified McClelland, all right, and Lesenby. Check. All right, check. Everything checks. Good. And then it says on November 28th, after his initial hearing, Allen is whisked away from Carroll County to White County without a safekeeping order authorizing. On November 1st, a letter from Mr. Allen is mailed from the White County Jail requesting counsel. Okay? So, what are the dates we're discussing here? 27th being notified. Okay, all parties having notice. 28th, there being an initial hearing and a moving of Mr. Allen. So let's get back to Nicholas McClelland. Okay. He says, the statute does not require the court to have a hearing. The defendant was taken into custody on October 26th. How is it Carroll County? Okay. So far, check. That an initial hearing was held on October 28th. where the defendant entered a plea of not guilty. Check. The court advised the defendant of his right to counsel, and the defendant notified the court that he would hire his own counsel. He at no time stated he had counsel. See order herein. Now hold up. Hold up. That's the bullshit. Is it not? Because they want to fuck around and find out. So let's let them find out. Let's let them find out. Hold on. So I know I have this, right? Shit. Let's upload it. Let's upload it. Let's see. Because we are asserting that on the 27th, they both McClelland was notified and where is it? Let's bring this one in. Oh, man. Okay. So what does this say? This says, to Brad Rossi from Brett Gibson, did you ever communicate with the prosecutor or law enforcement before Richard's arrest? No. Did you ever communicate with the prosecutor or law enforcement after Richard's arrest? Yes. On October 27th, Kathy notified me Richard had been arrested. We sent a letter to Carroll County Sheriff notifying them. I contacted Prosecutor Nick McClelland. Okay. All right. This is a copy from October 27th. Nick, I have been retained to represent Richard Allen. His wife, Kathy Allen, advised me that Richard was detained. She said he has not been released. Do you know Richard's whereabouts? Attorney Brett Gibson, Gibson Law Office. Okay. And then Ann Deedham sends to Carroll County Sheriff and Nick McClelland the attached correspondence. Okay. There's more. I wanted to show this one. It's called affidavit. Where is it? Oh, come on, what's taking all day? There we go. All right. Let's read it. I am a lawyer. Okay. Since November, I've been attorney for Richard Allen. In an attempt to learn whether Richard Allen's attorney, Brett Gibson, had communicated with McClelland or Lesenby or anyone else concerning the fact that he was representing Richard Allen, I reached out to Gibson. Attorney Gibson responded. Furthermore, in his email response, Attorney Gibson stated that he communicated with Nick McClelland both by email and cell phone and alerted McClelland that he was in fact Richard Allen's attorney. Furthermore, in his email response, Attorney Gibson stated that Prosecutor McClelland helped arrange a meeting between him and Richard Allen. Okay. Now, Do you understand what McClellan is doing here? Oh, I'm on page 2. Okay. Number E here. Initial hearing was held on October 28th. Remember, the night before, not the morning before, not 2 days before, not a week before, nor a month, the night before this hearing, McClellan was notified by email and by telephone. But they held the hearing on October 28th knowingly without the attorney. I would assume Alan was a little out of sorts to know that he should have said, hey, remember I have an attorney that came visit me last night? But you see how the gaslight is going. Okay, so back to this. It says in number E here, defendant notified the court he would hire his own counsel. He at no time stated that he had counsel. Hold on. Where are the ethics? Where are the ethics here? Because this it's not only a reflection of the prosecutor, this reflects back onto the judge. Where are the ethics? You see, they knew that he had an attorney. You can't say he didn't know. Okay, they knew he had an attorney. You see that? They knew he had an attorney. They knew he had an attorney. But you like how McClellan just skips over. He just totally ignores reality and the truth, the facts of the matter. Just like everything in this trial, just like the murders of Abby and Libby. Just totally ignore the facts and the truth and do what you want to anyway, because the judge will make it happen. He absolutely knew. Okay. But what they're trying to do is do this. It's this pull the old 1-2, right? He had no time stated he had counsel, even though I knew because I talked to counsel the night before. Okay, number F, that after the initial hearing, the defendant was moved to White County Jail due to overcrowding. He was not moved due to any safekeeping order. What the fuck? You see that one? You see that? You see that? Now that's how are they trying to get around moving him without a safekeeping order? We fucked up on that one. So just say that it was crowded. So we just moved him for crowding. You see, in every single bullet point here, they're going to ignore reality and just try to come up with some other excuse. Like I said, it took 12 days for this bullshit. They had to come up with some sort of response to every single point. Okay. On November 2nd, Carroll County Sheriff Tobe Lesenby filed a request by the sheriff to transfer inmate from the custody of sheriff to custody of DOC, commonly referred to as motion for safekeeping. November 3rd, the state received an email from attorney Brett Gibson stating that he would not be representing the defendant. Right, but we're talking about November 1st, October 28th. Okay, so November 3rd is quite a bit after November 1st. Remember, what was the argument? Let's check this out. The argument that Richard Allen's attorney made is that pull it up here. On November 1st, a letter from Mr. Allen was mailed from White County Jail. In the letter, Mr. Allen requested counsel. You understand? So, because of the prison mailbox rule recognized by the U.S. Supreme Court in Houston v. Lack, it's provided that pro se filings from an incarcerated litigant are considered filed at the time they are delivered to prison authorities. So the safekeeping proceeding on November 3rd should have included an appointed counsel. Okay, but let's get back to McClelland here. J goes down to J. Okay, so where are we? We're at. On November 3rd, the state received an email. Okay, I read that one. On November 3rd, the court granted the sheriff's motion without a hearing and determined that the defendant was in imminent danger of serious bodily injury or death, or represents a substantial threat to the safety of others, not based on any acts or alleged acts of the defendant, but the insistence of public information, noting that is extremely dangerous and put all public servants in a dangerous situation. Remember, that was the bullshit Diener letter where he tried to blame the public for his issuing the safekeeping and then immediately recusing himself. But I've shown that in the last one, or in the last show that we did, which covered this, that what was actually happening is that Diener penned the safekeeping request for Lesenby. You like how McClelland leaves that part out? Do you like how he leaves that out? He completely ignoring reality. Now that's why we got both to AB, right? To compare. The court further noted the defendant intended on hiring private counsel, further supporting that no attorney had entered their appearance. You see how he's playing the game? Do you see the game that's being played there? So listen, if Mr. Gibson did not properly take care of the problem, that's ineffective assistance of counsel on the part of Mr. Gibson, right? If McClelland and Lesenby and Diener did something wrong, that's error on their part, correct? Let me ask you this. Where in any of this does it say that the defendant should suffer for the negligence of any of the attorneys or sheriffs or judges or anyone involved in this? Because what it looks like right here is a bunch of passing of the buck. Okay, Gibson says, yes, I was hired. Yes, I sent an email. Yes, I made a phone call. McClelland saying, no, you didn't file an appearance. You didn't do this. Diener saying, yeah, well, I wrote it, but I didn't write it, but I wrote it, but I didn't write it, but I just stepped down. And yes, it was because I fucked up and I wrote it and I did it when I shouldn't have because there was no legal standing, but I'm just going to recuse myself, but I'll just blame the public instead. But in any of this bullshittery that's going on between these parties in this fucking corrupt Carroll County, where in it is Richard Allen making a mistake? Where he has to suffer the consequences of his mistake. I don't see him making any mistakes. Seems like Kathy Allen did the right thing. She put down $5,000 to retain the services of Mr. Gibson. Seems like Richard Allen did the right thing and he requested state-appointed counsel. Seems like the husband and the wife Both tried to ensure that he had counsel. But all of these attorneys are fucking around, negligent, bullshitting, colluding with the judge and the sheriff, and Richard Allen has to suffer? Where did he go wrong here? See, I didn't want to do this. I'm telling you now, I didn't want to do this show because Nicholas McClellan makes me so infuriated that I literally want to rip this shit up, throw it at the wall, scream and yell, and slam something into the computer and break it. Like, I don't want to read these gaslights. But again, that Judge Diener was a presiding judge over the case at the time, therefore had jurisdiction over the case, and further was in jurisdiction and within IC 3533.11.1 to make a ruling on the motion without a hearing. Yeah, but that's not the question. You see, you fuckface. That wasn't the question. The question was, did Lesenby have jurisdiction, right? So let's read that again, because I'd rather read these defense filings because they're more reflective of the truth. Let's read it. The safekeeping proceeding, I'm reading at the bottom, was plainly illegal from start to finish. First, Sheriff Lesenby transferred Mr. Allen to White County Jail on October 28 with no safekeeping order in place. Next, Sheriff Lesenby had no standing to make a safekeeping request on November 3rd due to the fact that Mr. Allen had been illegally transferred to White County Jail. Once Mr. Allen was in White County Jail, White County Sheriff was the sheriff who was authorized to make the safekeeping order by statute under Indiana Code 3533.11.1 because Sheriff Lesenby had no standing to make a safekeeping request. Judge Diener had no jurisdiction because it was void, because it's void if a judgment is granted, if it grants rights or relief to a party that does not have standing. And remember, Sheriff Lesenby, according to these attorneys, did not have standing at the point in which he handed in Diener's own handwritten request. But listen to this one. Second, Mr. Allen had a right to have a judge other than Judge Diener decide the issue, okay, because Judge Diener had engaged in ex parte communications with Sheriff Lesenby, helping Sheriff Lesenby draft the safekeeping request in violation of Rule 310 of the Code of Judicial Conduct. Well, you know what? Let's pull a prof, okay? Let's pull a prof. Let's say Indiana Code of Judicial Conduct, okay? Indiana Code of Judicial Conduct. Let's go to 310. Was it 310? It says Rule 310. Okay, so let's read Rule 310. Are you ready? We're just going to read straight from the Indiana Court Rules website. Rule 310, practice of law. A judge shall not practice law. A judge may act pro se and may, without compensation, give legal advice to and draft or review documents for a members of the judge's family, but is prohibited from serving as the family member's lawyer before a tribunal. The rule does not prohibit the practice of law pursuant to military service. A judge may act as a pro se in all legal matters, including matters involving litigation and matters involving appearances before or dealing or other dealings with governmental bodies. A judge may not use the prestige of office to advance the judge's personal or family interest. The judge's assistance to family members. Okay. So what is this saying? A judge cannot give legal advice or draft or review documents. However, a judge may do so for a member of the family. Okay. Well, the question then is Tobe Lesenby a member of Benjamin Diener's family? Rule 310 prohibits judges from drafting or reviewing documents except for family members. Now it says Judge Diener also violated Rule 2.9 of the code by engaging in substantive ex parte communications. Well, let's go look at that. 2.9. Okay, 2.9. Let's go back. 2.9. We're reading directly from the Indiana court rules. 2.9, ex parte communications. A judge shall not initiate, permit, or consider ex parte communications or consider other communications made to the judge outside the presence of the parties or their lawyers concerning a pending or impending matter, except as follows. When circumstances require it, ex parte communication for scheduling, administrative, or emergency purposes, which does not address substantive matters, is permitted, provided the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication, and the judge makes provision promptly to notify all other parties of the ex parte communication and gives the parties an opportunity to respond. A judge may obtain written advice of a disinterested expert on the law applicable to a proceeding before the judge. If the judge gives advance notice to the parties of the person to be consulted and the subject matter of the advice to be solicited, and affords the parties a reasonable opportunity to object and respond to the notice and to the advice received. A judge may consult with court staff and court officials whose functions are to aid the judge in carrying out the judge's adjudicative responsibilities, or with other judges, provided the judge makes reasonable efforts to avoid receiving factual information that is not part of the record and does not abrogate the responsibility personally to decide the matter. A judge may, with the consent of the parties, confer separately with the parties and their lawyers in an effort to settle matters pending before the judge. The judge may initiate, permit, or consider any ex parte communication when expressly authorized by law to do so. If a judge inadvertently receives an unauthorized ex parte communication bearing upon the substance of the matter, the judge shall make provision promptly to notify the parties of the substance of the communication and provide the parties with an opportunity to respond. A judge shall not investigate facts in a matter independently and shall consider only the evidence presented and any facts that may be properly judicially noticed. A judge shall make reasonable efforts, including providing appropriate supervision, to ensure that this rule is not violated by court staff, court officials, and others subject to the judge's direction and control. To the extent reasonably possible, all parties or their lawyers shall be included in communications with a judge. Whenever the presence of a party or notice to a party is required by this rule, it's the party's lawyer, or if the party is unrepresented, the party who is to be present or to whom notice is given. The prescription against communications concerning a proceeding includes communications with lawyers, law teachers, and other persons who are not participants in the proceeding, except to the limited extent permitted by this rule. A judge may initiate, permit, or consider ex parte communications expressly authorized by law, such as when serving on therapeutic or problem-solving courts, mental health courts, or drug courts. In this capacity, judges may assume a more interactive role with parties, treatment providers, probation officers, social workers, and others. A judge may consult with other judges on pending matters, but avoid but must avoid ex parte discussions of cases uh, with judges who have previously been disqualified from hearing the matter and with judges who have appellate jurisdiction over the matter. The prohibition against a judge investigating the facts of a matter extends to information available in all mediums, including electronic. A judge may consult ethics advisory committees, outside counsel, or legal experts concerning the judge's compliance with this code. Such consultations are not subject to the restrictions of paragraph A2. A judge is permitted by Rule 2.983 to consult about legal procedural issues with the Indiana Office of Judicial Administration. So, did you say anything in there allowing the ex parte communications with the sheriff and the assistance of the drafting of any safekeeping requests, etc.? And had he done that believing he was in compliance with the rules, should he not have notified the other party? Shouldn't have notice have been given? Okay. Having violated both Rules 310 and 29, Judge Diener was obligated under Rule 211 to recuse himself. Well, let's go look at 211 because we're not leaving any gaps here. Okay? Back to it. 211. Let's do it. Disqualification. A judge shall disqualify himself or herself in any proceeding in which the judge's impartiality might be reasonably questioned, including but not limited to the following. The judge has a personal bias or prejudice concerning a party or a party's lawyer or personal knowledge of facts that are in dispute. Whoa, sounds like Judge Gull should have recused herself 2 years ago, doesn't it? The judge knows that the judge's spouse or domestic partner or person within the third degree of a relationship to either of them, or the spouse or domestic partner of such a person is a party to the proceeding, acting as a lawyer, person who has more than a de minimis interest, likely to be. Oh, sounds like the judge should have Judge Gull should have recused herself for that as well. Number 3, we'll skip. Number 4 is reserved, so we don't even have the knowledge of what it is. Number 5 says the judge, while a judge or judicial candidate has made a public statement other than in a court proceeding. Well, Judge Gull should have recused herself. Remember the screenshots from Facebook of Judge Gull? Right. The judge served as a lawyer, served in the government employment, was a material witness, previously presided as a judge. A judge shall keep informed about the judge's personal and fiduciary economic interests and make a reasonable effort to keep informed. A judge is subject to disqualification under this rule, shall, other than for bias or prejudice under paragraph A1 or for conflicts under paragraph A2, Yeah, that's under 8. So I'm skipping a bunch because it's a lot to read, but here A to B, acting as a lawyer in the proceeding by drafting that safekeeping request. A judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. Third, Sheriff Lesenby's November 3rd request by the Sheriff of Carroll County, Indiana, to transfer inmate from the custody of sheriff to the custody of DOC for safekeeping was not served on anyone. There's no certificate of service attached. Indiana Code 3533.11.1 requires a safekeeping request to be made by motion. Okay, so that seems to be a point of contention too. Now, this is citing Indiana trial rules 5A2 and 3. Required Sheriff Lesenby's motion for a safekeeping order be served on both parties because Sheriff Lesenby knew that Mr. Gibson was representing Mr. Allen. He was required to serve Mr. Gibson. Even if he claims Mr. Gibson was not representing Mr. Allen, Sheriff was required then to serve Mr. Allen personally. Fourth, Sheriff Lesenby's safekeeping request was not verified. There was therefore literally no evidence before Judge Diener from which he could make a factual finding. Fifth, because a factual finding was required to authorize a safekeeping order, a hearing with notice to the parties was required. Sixth, Mr. Allen had a right to refuse. Okay, so let's go back to McClellan. Where are we? All right. Indiana Code 3533.11.2 does allow the defendant to request a post-transfer hearing. The defendant requested a hearing which was held on June 15th, 2023. June 15th, 2023, the court found the defendant's allegations were untruthful, not well-founded, and denied the motion. The court further found that safekeeping order was reasonable and necessary to ensure the defendant's safety and prevent serious bodily injury to himself, therefore affirming the court's order of November 3rd. Therefore, the defendant had a right to object and exercise that right, and his counsel failed to show. Okay, the defense filed an additional verified motion for immediate transfer on September 18, 2023, which the court denied without a hearing. That the defendant's due rights process and constitutional rights were protected through the course of this case. You like how everything that benefits him is what's put into here. Hold up. I see we got a retard in the chat. Just a moment. Let me deal with him. Someone who likes to threaten people with the FBI. Send him, bitch. Send him. Oh. What a retard. Come on, man. How does he even get in here when I blocked him? Like, dude, buy a life. All right. Just can't. I have to deal with psychos. See, I have to deal with psychos 24/7, bro. Delphi for you. It's Delphi for you. Psychos all the way around. Oh, God. Yeah, well, everyone laughs at him for good reason. He whines about people laughing at him, but he cries like a baby. Like, you're a grown man, dude. Stop shaming yourself. All right, so let's see. Where were we? You see, he's trying to throw me off track, though, because he's not important and this is. All right. Now, where are we? All right, here we go. Please, let's move on. Number T. McClellan claims that under both the Sixth Amendment of the U.S. Constitution and Article 1, Section 13, the right to counsel only applies to critical stages where the absence of counsel might derogate from the accused right to a fair trial. Further, a stage of the proceeding is only critical if it's one where incrimination may occur or where the opportunity for effective defense must be seized or foregone. The right to counsel is not a generalized protection for all purposes. It is not a right that is implicated just because of the questions of law may arise. The motion for safekeeping does not touch on matters of guilt or impact the ability to have a fair trial. It is a mechanism for housing the defendant in a penal facility pending trial that will keep him and others safe. The defendant is not facing the advocacy of the prosecutor with respect to his guilt or innocence of the criminal charges. It is further not a stage where incrimination may occur or where the opportunity to present a defense to the charge must be seized or forever be lost or impaired. It has been found that the filing of information is not a critical stage. The probable cause hearing or the initial hearing are not critical stages, nor is the procedure to select a special judge. It is safe to surmise that given those rulings, a motion that does not even require a hearing would not be a critical stage. All right. So, they're going on with the same shit. It wasn't a critical stage. Like I said, it's going to actually take specialists or knowledgeable trial attorneys and judges to determine this. It's not something that we are going to know or that we can take the word of the prosecutor for or the defense attorneys. Okay, but it should be pretty well established whether or not that could be considered a critical stage. I'm serious. I can't even keep reading this shit. I can't even keep reading. It's infuriating. But as I mentioned, and I believe that the defense attorneys might have referenced this, but if that be the case in law, you have to think about this. Something needs to change. Something needs to change it, and these safekeeping orders need to be considered critical stages. Why? Think about what happened to Richard Allen. Think about it. It's a critical stage. Why? Because it severely affected the outcome of this case against Richard Allen. Why? Because he was placed in a maximum security facility in solitary confinement for a year, wherein he went into a psychological break. He deteriorated closely to the point of death. Right? His weight tanked 40 plus pounds. He was eating his own feces, banging his head on the wall. He almost died. And at the very time when he was experiencing this crisis, he was being forcibly medicated and brainwashed by Dr. Monica Walla. He was being threatened by the guards, the white nationalist Odinist guards, and the other inmates. And at that very moment, he was compelled to confess to the crimes. Okay, so why do I say that it needs to be considered a critical stage? If it's not currently considered a critical stage by law, the law needs to change. These need to be considered critical stages because in a scenario like this, where you get a pretrial detainee placed in the hole for over a year, wherein he loses his mind and he starts to confess to crimes, which then affects the outcome of his charge or of him being charged. Remember, he said the guys with the Odin patches were threatening to kill him. He was consistently asking whether his wife was okay and his daughter was okay. He was rolling around on the floor in his own urine, feces, and food. He was confessing to shooting the girls. to sexually assaulting the girls. Were they shot? Were they sexually assaulted? How did Gray Hughes have prior knowledge of what later came out in trial regarding his alleged confessions to Monica Walla? It could only mean two things. One of two things. It either means that Monica Walla was telling Gray Hughes what Richard Allen was saying, or what there was the substance of their discussions, which would mean HIPAA violations and she should permanently lose her license. Or it would mean that Monica Walla was telling Nicholas McClellan, who was then somehow feeding the information to Gray Hughes. So the whole deal that Allen was speaking with a insane fan of the Delphi murders who consumed all the podcasts on the Delphi murders while forcibly medicating and treating Richard Allen at this critical stage of or this critical time period, which was, remember I said it was June, July, August, not June, July, April, May, June, July. April, May, June, July. Especially in June. But during this summer time period, Richard Allen's at the absolute peak of his depression, psychological breakdown, his mental crisis. At the peak of this crisis is when he's giving up these confessions, which are being coerced by a combination of factors. The mental health provider, who's the Delphi fangirl, the guards, who are white nationalist Odinists, and the other inmates. All of these are compelling him. You better confess. You better confess. Tell me about the van. Tell me about the knife. Tell me about the box cutter. Did you have box cutters from work? Oh, did you see a van? Oh, did you sexually touch the girls? Oh, did you chase them across the water? Ooh. Anyhow, what I'm getting at is that this ended up being a very critical stage in reality, whether or not it's technically considered at this point in time. You have to think about that because it could be you. So if you're going to be thrown into a prison and put into solitary confinement for more than a year as a pretrial detainee, don't you believe that the courts should consider that decision or that juncture or that stage to be a critical stage? So I'm not sure if what's going to flesh out if he's technically correct or not, but I don't think it matters because we should be talking about ethics. We should be talking about principles of truth and freedom and right and wrong. And that's why I consistently mock these people. This is clearly wrong. This is clearly wrong. The blood thirst, the blood lust of Delphi that was referenced incorrectly by old Benjamin Diener, it actually, you see where it's coming from. The blood lust is coming from the judge's office, the prosecutor's office, the sheriff's office, Kathy Schenken, her daughter. Are we understanding where the bloodlust lies in Delphi? But listen what he says, it's even worse. It's even worse. Let's see. Okay, here we are. Listen how they fucking see they love to rub it in your fucking face. That's how shitty these people are pieces, literal white pieces of shit. W, that even if this was determined to be a critical stage in the proceedings, any Sixth Amendment right to counsel would be reviewable under the harmless error analysis. Whoops! I'm dickless, and this was harmless, like my dick is, says McClellan. The defense cite U.S. v. Chronic as precedent to overturn the conviction, but they do so because they misunderstand blah, 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 blah. Okay. However, this raises questions whether the Sixth Amendment violation has occurred and whether the constitutional violation was harmless. Harmless. Prejudice must be an element of the constitutional violation to warrant reversal. In Chronic, the issue is was ineffective assistance of counsel, not lack of representation at a critical stage. In determining if not having an attorney at a critical stage reaches a level of a violation, the harmless error analysis is used. Listen, I guarantee you, the judge gave him this verbiage. I guarantee you the judge. Look, do you think that little dickless young motherfucker knows the law well enough to cite harmless error? Come on, dude. This dude barely got out. It's only the fucking lines and drinking that got him through law school. 12 days to write this because you needed someone to hand you harmless error analysis as a talking point to put into your argument here so that the judge can go ahead and check. Someone wrote this for him. Okay, let's be real here. Someone wrote this for the state. This ain't McClelland. Let's be real here. None of you are stupid in this chat. Only fucking Michael and you other fucking trolls. The lack of a hearing for safekeeping on November 3rd, the lack of counsel before the decision was made by the court had no effect on the jury's verdict and therefore is harmless. No effect on the jury's verdict. Hello? It had a great effect on compelling him to confess by him being in the middle of a psychological crisis and medicated and being tortured and abused and being treated by a Delphi fangirl who just so happens to be like, what do you think are the odds that this Delphi fangirl happened to be the doctor assigned to him at Westville? What do you think the odds are that the guards who were in charge of him were these white nationalist, Nordic pagan Odinist freaks? Had no effect on the jury's verdict. Just as a fucking joke. This is an absolute joke. Absolute joke. Let's be real here. Judge Gall handed you this document just like Diener handed Lesenby the safekeeping request, right? That's how it's done in Indiana. Due process under the 14th Amendment as it pertains to Brad Weber. Oh my God, I don't want to get into that. All right, let's check this out. All right, so look, Brad Weber right here. This says, in violation of the Due Process Clause of the 14th Amendment, Napui claim the state presented testimony of Brad Weber, which they knew was false, or failed to correct. Okay? Remember that we went through this in detail. I don't feel like I should have to go through it again. But let's be real here. Let's be real. The state knew that Weber was lying. And if they didn't think that he was lying, they knew he was wrong. Okay? So maybe they didn't say, oh, we know that he's intentionally lying. But they knew he was wrong. They knew what he was saying was wrong, whether they believed it to be intentional or not, a lie or not. They knew it was wrong. And remember, this story, like many here in this case, don't you find it odd that all the witnesses and family members in the Delphi murders case for 7 years have all been lying, inconsistent? Their stories have never added up. They can never remember the details of their lives, of their lies. So there's always conflicts. Every time they tell the story, it's something different. Story constantly changes because they're lying. You see, when Kelsey ran around for years saying that it was about 1:30 when she dropped those girls off, or before, did they not know that was a lie? Um, I don't know who else. When Sarah Carbaugh suddenly changed her story from muddy, 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 and then suddenly in 2019, bloody, 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 bloody. They didn't know she was lying. When Daniel Pearson didn't tell the truth about who he was with or what time he was there, and then changed it several times. Or when the little three classmates and the family collectively lied about what time those little girls were there. Or the fact that Cheyenne, where your car was parked, when it was parked, where, why you moved it, how early you were there, and what time you said you got there versus what time you actually got there. Mm, I don't know what other witnesses. There's every so fucking single one of them have lied. All right, and then we got, let's see, the sheriff lied, the prior sheriff lied, the ISP lied, the other ISP lied before him, and then there was all your fucking cops lied, and your searchers lied, and your Pat Brown lied, and David Erskine lied, and fuck Jesus Christ, so everybody lied. Why? Murder of 2 little girls, and you're lying. Hmm. And it's odd that no one wants to put themselves there between the time 2 o'clock and 2:45. Why is it that no one in that 2 o'clock hour is there? You got all these people. Like back up, okay? Let's do the 30,000-foot view of the case. In reality, you got all these fucking people there before 1:30. Think about it. All these people all day. They got all these people there before 1:30. You got all these people there after 3:30. But you mean to tell me that hour or so when those girls go missing, quote unquote, that little time frame, suddenly nobody's out there, nobody sees nothing. All these people before, all these people after, but then that little chunk of time, oh, nobody's there. Nope, I ain't seen nothing. I ain't seen nothing. No one's there. I wasn't there. I wasn't there. I wasn't there. I was there. I was there. How likely is it? Come on, man. Since when does a place that's busy and there's all this traffic, since when does it suddenly in the middle of the day, just all of a sudden, zoop, no one in sight? You can't even nail down Betsy Blair to say that, yes, I absolutely saw Abby and Libby alive. I absolutely saw them. Yep, yep, yep. No, she leaves the door open for us to say, oh, you probably saw Kelsey and Bree, and Kelsey probably lied. Why is it? Why is it that in that golden hour, no one wants to be that place and time? Including Brad Weber. Anyway, I'm getting off track because I'm supposed to be doing this. Okay. Where are we? I didn't want to do it. Okay, here we go. Due process as it pertains to Brad Weber. All right. The defense argues that the defendant's due process rights under the 14th Amendment of the U.S. Constitution were violated because the state presented testimony that Brad Weber arrived home in a white van around 2:30 p.m. knowing that the testimony was false before it was elicited, or failing to correct it once it had been elicited. Yeah, I believe that. The defense cites a video located in discovery from the residence near the High Bridge, a video that was included in discovery, turned over to defense, and that defense had the entire time of trial. That the exhibit presented by the defense is a form of a YouTube link that is not identified as an item of evidence by an Indiana State Police number, and therefore is an improper submission for consideration by the court. It is unverified by legitimate means as to date and time. Defense alleged that the time in the video is off by 12 hours without any proof of said allegation, except their apparent ability to tell time by simply looking at daylight and moonlight in the video. They further make assumption about the content of the video. They present zero evidence to support said allegations. That the simple answer is that a motion to correct error only applies to newly discovered evidence from the defense's own admissions, This is not newly discovered evidence, but rather evidence they had been provided long before trial. The defense chose not to present it at trial as part of their trial strategy. It was a trial strategy by experienced defense trial attorneys. Therefore, it is a moot issue because it's not newly discovered evidence. That at best, that is impeachable evidence that the defense could have used when Brad Weber was on the stand testifying. Evidence which is merely impeaching is not available as grounds for a new trial under the rules concerning newly discovered evidence. Further evidence must be more than impeachable or cumulative, must not be reasonably discoverable before trial, and also evidence that would probably result in a different verdict. It must be more than contradictory. Finally, the testimony by Brad Weber was not the exclusive evidence the state used to convict Richard Allen. Brad Weber was put on the stand multiple times, and the defense had every opportunity to cross-examine. If anything, this evidence is no more than impeachment that the defense chose not to use. The defense is not permitted to request a new trial to change strategy when their chosen path fails. This also applies to any phone pings that were in discovery for Brad Weber. Well, I think, okay, I'll give you my take on that. I think it's twofold. My take on that is twofold. A, he's right on the first half. Defense fucked up big time. I've said that so many times. Defense fucked up big time. And they knew it. I mean, obviously they know it. They lost. If you don't think they fucked up, get out of here. You don't belong here. I mean, look, we talk honestly here, openly. Defense fucked up big time. First of all, they rested a week too early, like idiots. Okay? They were overly confident. They read the room wrong. They were fucking heads up their asses. They fucked up. If you don't agree, go somewhere else where people will tell you kind things you want to hear. So he's right on that half. Now where he's wrong, the prosecutor did know that evidence to be false. So I don't know how that works out with the law. I'm not a lawyer. Go fucking listen to lawyers, figure out what they say to you. But like I said, I think Andre Burkhart said it pretty fucking well. Pretty well. Ineffective assistance of counsel. They fucked up real bad. They can't stumble onto this now and say, oops, look what we found in discovery. No, too late. Way too late. However, true, this prosecutor should have known. Okay, let's go back. Let's go back to this. Back to the defense's claim that the state used false evidence. Yes. Okay. They used false evidence. They knew that this time, let's be honest here, because, you know, this came out several days ago. I don't know if you caught this. Let me reference this because I can't, it's unbearable. I almost can't bear it. It's intolerable. This shit is intolerable to even fucking, it's, what's the word? What's the word? Nicholas McClellan is insufferable. It's just, but listen to this, okay? Let me see if I can find it. This is a quote from Stacy Diener, one of the prosecutors. One thing about this case that is interesting, and I think maybe it was a challenge to some people who aren't super familiar with trials, is it wasn't like television. There wasn't like one single piece of dramatic evidence that conclusively proved anything. It was like the totality of all things kind of fit together and gradually built a box around Richard Allen, who of course killed two girls. And a crucial piece of all that was the trial witnesses, which you handled. Okay, so, well, actually, that was one of Murder Shit's talking to Diener, but the point was, listen, they all knew they had no case. Like I said, this was never meant to go to trial. That's why they tried to force him to plea by putting him in Westville. You see how you reverse engineer this shit? They put him in Westville to try to force a plea. It didn't work. And I've said many times, but as a side effect, the benefit of that is they got the false confessions. Anyway, back to this so we can get through it. So like I said, on that particular point with Weber, I agree with McClellan, 50%. The defense fucked that up. It's their fault. But on the other side, you, sir, allowed false evidence knowingly. So we'll see how the appeals courts or the Supreme Court handles that. All right, and I got to say, if you're already mad at me for saying that, you're going to get more mad. Haters, come on, haters, prof haters, come on. Especially those of you in the lurker crew. I know you hate me, and I love it. Fuck you. The Reese Davis Confessions by Ron Logan. I got to say, I'm probably going to be with McClellan 100% on this. So all you motherfuckers who hate Ron Logan and think that he killed those girls, you're about to be real mad at me. But hurt time. Defense argue that Reese Davis claims that Ron Logan made a confession. Said claim being newly discovered evidence. That any information pertaining to Ron Logan falls under the state's motion in limine. The defense had 3 days to present evidence to meet their burden for third-party motive. They mentioned Ron Logan, but failed to meet their burden. They chose not to present this evidence. They also did not present this evidence when they renewed their motion. This now seems to be an effort to use a motion to correct effort in effort to circumvent their burden concerning third-party motive. This evidence, along with the video surveillance from the residence received on January 30th, is released as State's Exhibit 7, that the defense, consisting of 3 experienced defense trial attorneys, made a choice to not fully explore or present the Reese Davis claim, which defense admits was contained in discovery, that the alleged confession was made to an inmate serving 50 years for meth dealing. Ellie interviewed him and he submitted to a polygraph. He gave a statement that alleged Ron Logan confessed to him, blah, 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 blah. That he killed the second victim later, blah, 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 blah. You remember all that. Everyone was excited, right? So excited about Ron Logan. That he removed the cell phone battery from the girl's phone and left the phone behind, and that he took the girl's clothing from the scene and burned. Many of those details are directly contradicted by the evidence, and others have no evidentiary support. That even with the alleged information from Ron Logan about the box cutter, there would have not been enough to establish probable cause to arrest Ron Logan. Obviously, there wasn't, because as I've said, if they had anything on Ron Logan, they would have been arrested and tried his ass for the Delphi murders. Get over it. All right. So here, anyway, like I said, fuck the Ron Logan. Okay, because once again, ineffective assistance of counsel. They fucked up. All that shit was in discovery. They fucked up. Now, what's interesting to me, what could have been addressed is box cutter, Monica Walla, Gray Hughes, medical examiner, and Nicholas McClellan. You see, that's what could have been used to say, hey, Monica Walla says that Rick Allen confessed, quote unquote, to using a box cutter. Well, it's odd because after that, McClellan meets with the medical examiner, who suddenly, after several meetings, changes his mind and has a revelation and says, hey, you know what? I actually think a box cutter could have been used. Well, what's interesting about that is you go back to 2017 and you had this guy talking about Ron Logan talking about a box cutter. But as a great point that Dick Snay, Ricky Smallballs, Dickie Smallballs, Smallballs, Ricky Deaky Leaky, my buddy Rick Snay makes is that, listen, fuckface, if a box cutter was ever a thing, I guarantee you that law enforcement would have taken every box cutter that Rick Allen owned when they went and served that search warrant. Because they took some knives and they took some phones and they took some clothes and they took a gun and they took some bullets. But you know what they didn't take? Not one fucking box cutter. And how do we know that? Well, first of all, you know that because it's not on the search warrant return. When you read the search warrant, read the return, zero about a box cutter. So Ricky Deaky Leaky asked Kathy, hey, Kathy, when they came and they took all your shit, did you have any box cutters? Oh, yeah, we had several. Did they take even one box cutter from you at all? Did they take any box cutters? No, they didn't take the box cutters. Box cutter's still here. It's fine. Box cutter's fine. And that's the truth that no one wants to hear about this case. It's the obvious truths. Listen, everything in this case that's piled on top of Rick Allen was done so by reverse engineering. They put Rick Allen at that place and time by reverse engineering. He didn't put himself there at that place and time. The tip on Rick Allen was found by reverse engineering. You don't believe that story, do you? The supposed things only the killer would know that Rick Allen allegedly said, they put on the Rick Allen by reverse engineering through Mauna Koala. The witnesses, they reverse engineered to pile on to Rick Allen, and they omitted the witnesses who would cause one to not focus on Rick Allen, and they included witnesses and twisted their words. Remember, there were several vehicles described. Remember, a white pickup truck. Remember, a purple PT Cruiser, etc., etc. 1965 Comet, etc., etc., etc. So many vehicles described. What did that sheriff do? He turned all of those vehicles into one vehicle, which is Rick Allen's vehicle, reverse engineered it. And he omitted the 1965 Comet because couldn't turn that one into Rick Allen's. The sketches, the reason they were thrown out, because they were not Rick Allen. So the way they dealt with that, get those sketches out of here. The witnesses not identifying Rick Allen because they knew he couldn't. They knew those witnesses couldn't. So therefore, the witnesses didn't. I love how everyone always says, ugh, Well, he got rid of the phone he used that day. Blah, 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 blah. Yeah, really? Okay. You don't think they went and they subpoenaed the service providers for all of his records so that they would have known? Come on, man. All right. And here's the part where you're actually going to get most angry. So let's get it. Listen, that whole excuse that Doug Carter uses, we kicked the FBI off because it's just too much going on and too many chiefs, not enough Indians, and we just need to have to pull it all under one roof. That's why we kicked the FBI off. Right, right, right. Yeah. Stacey Eldridge. And this is the one that is especially damning, right? With Stacey Eldridge. The defense alleges that an affidavit by Stacey Eldridge supports that dirt or water did not cause damage in the auxiliary jack in order to log wired headphones were plugged in and unplugged. They allege that this is newly discovered evidence that would probably produce a different result. Stacey Eldridge testified at trial for the defense. She did not submit any report, log, or any other information that supported her position that the log accurately supports that headphones were plugged into and later unplugged from the auxiliary jack. That this opinion was only supported by her testimony at trial. Prior to her testimony, Stacey Eldridge had only done one other forensic phone analysis and had only testified one time prior about a forensic phone analysis. Stacey Eldridge only gained the education to be able to testify to a forensic phone analysis as recently as 2023. That the bulk of her expertise is in computer and network forensics, not cell phone forensics. That the state called Sergeant Christopher Cecil on rebuttal to testify about headphones in the auxiliary jack of the phone. Cecil was able to observe photos of the phone when it was found. Cecil did testify that one plausible explanation for the log entry is that there was dirt or water in the jack that caused a malfunction. This is in part based on the condition that the phone was found in, how long it was outside before it was found, and his knowledge and experience as a phone examiner. This is also based on facts found through the investigation, including that the phone did not move after 2:32, and there were no headphones found. Oh my God, this is where it gets so fucking stupid. This is so fucking stupid. I'm when I tell you I don't want to read this. I don't know. These people get away with murder. You see what I'm saying here? These people get away with anything. They are willing to say anything, no matter how corrupt and negligent and I guess just fucking horrible they look. Like when you talk about sell your soul to the devil, this guy's literally sold his soul to the devil. There were no headphones found with the bodies. And that has to do with what? How's that fucking relevant at all? Did someone so in your meeting with Judge Gull and Murder Sheet and the other fuck faces, you just decided someone said you should put that in. Just put that there were no headphones found with the dead girls. I mean, I'm speechless at that one. There were no headphones found with the bodies. That it is unlikely that someone returned to the crime scene after 2:32 p.m. No, it's not. It's very likely that that many people were around the crime scene. Remember, the geofencing alone shows that you refused to allow in, and of course, the judge just greenlit all that. I can't even read the rest. I can't even read the rest. The defense's expert, Stacey Eldridge, sat in the courtroom during Cecil's testimony, and the defense had an opportunity to recall her as a witness to rebut Cecil's testimony, but chose not to, which is where they fucked up. Anyway, look, I'm done with it. Let's look at, because you see how they tried to disparage her credentials there. Let's look at this, okay? Because what they just tried to do was basically say she's a dumbass and Cecil's Google search is genius. Okay, remember what she reviewed. Okay, let's go over to it. Let's see. All right. Here, well, fuck it. Let's see. Let me get her affidavit. That was a better document. Oh my God, dude. I can't even handle this anymore. Here we go. Affidavit. Oh, that's not it. That's it. All right, let's look at it. Because remember, I said that. Remember, Cecil didn't even know what to do with iPhones. He was clueless about iPhones. Basically, less experienced than Eldridge. When it comes to the explanation about dirt or water being in the headphone jack, he pulled that out of fucking thin air. By a alleged Google search that pulled up a single response from some Apple group chat or forum. But this lady, okay, this lady here, let's see, FBI from 2003 to 2012, digital evidence instructor, computer analysis response team, senior forensic examiner. What was it, 2012 through 2017, she was a, senior cyber investigator, program manager at GE. Okay, 17 to 19, director of cybersecurity at Lincoln Electric, adjunct professor, several universities, provides digital forensics, mobile forensics through her business, receives her master's of science in 2008. Okay, has the following FBI certifications here. FBI certified cell phone forensic examiner, Celebrite certification, okay, access data certified examiner, FBI computer analysis, PDA forensic examiner, previously served at 3 prior expert as an expert witness at 3 prior trials and at the Richard Allen, okay, claims that Liberty's phone showed wired headphones plugged in, wire headphones unplugged. 544 and 1032 respectively. No indication from Miss German's phone that indicated that the water sensor identified water damage. She reviewed all of Cecil's reports and the 2 early ones from Brian Bunner. The photos also show 0 dirt, no indication of water damage whatsoever. You see all that? So here's where we're getting to the truth of the matter again. And like I said, the funny thing about these people, there's 0 regard for the truth of the matter. Where are the ethics with these people in Indiana? Okay, sorry, I'm done with this. I'm trying to pull it down. Get out of here. So where does that leave us? Where does this leave us? Like I said in the beginning, it's a spoiler alert. Be prepared. This judge is just going to listen to every single word McClellan says, and she's going to deny the motion to correct error because it's what she does. She's completely unhinged and biased. Okay, it's completely evident. It's obvious. There's no arguing that. I mean, even Mike Patty had to thank her for keeping things on track, as he said, keeping the railroad on its tracks. See, they never cared about getting the right person or people who committed this crime. They just wanted somebody. I mean, ultimately, that's the conclusion that we come to at this point. Remember what I said in the beginning 2 years ago. I believe the first intention was they were trying to set up Ron Logan. It's why they put those girls on his land. The point was to set up Ron Logan. I believe if they planted the bridge guy video, it was done to implicate Ron Logan. I had always thought, and I'll say this, I always thought that what they did is they took video from one of Ron Logan's trail cams, and they took the image of Ron Logan and turned it into bridge guy, somehow pasting it on the bridge and then planting it on the phone. Well, I'm not sure at this point if that's what happened, because remember, we still have not seen. Someone made the mistake, came into my channel the other day and said, I saw the original bridge guy on such and such's channel. No, you didn't. No, you didn't. That has not been released. It's not been leaked. It's not been published. It's not been released. So we still haven't seen the original bridge guy. Okay. All we have seen, I guarantee you, promise you, all you have seen is the enhanced bridge guy. They're different versions of him. Initially, the first enhanced version of bridge guy, he was slimmer and taller. He was tall and slim, and he was also in black. Okay, then the next version of Bridge Guy they released, he was shorter and wider and in blue. So he magically he changed colors, he changed height, and he changed weight. But those were both in enhanced versions, photoshopped. Okay, you see, when we were doing the analysis of the metadata, it was clear that was photoshopped, produced in Photoshop. So we always knew that, and we wondered, why has it been photoshopped? And the excuse they gave early on was it's been enhanced by the ISP. So there's no question that what we've all seen, any of us out here, it's photoshopped, it's enhanced, it's possibly from a trail cam and then cut and pasted, but we'd have no way of knowing without seeing the original and analyzing the original and even seeing the metadata on the original. Okay, so we are still waiting for that. Same with the audio. We're still waiting for that. But I always believed that uh, they were intending to get Ron Logan. Okay. But what happened, it failed because when the FBI went in there, remember they exercised there were so many agents combing through his property. Okay. They locked him up for years because they thought they would be able to get his ass. They couldn't get him. There was nothing to get. They went through all this shit. There was nothing to get. So they eventually they realized we can't get Ron Logan. Okay. Well, then they moved on. I also sort of think at this point that there was some attempt to aim at Brad. Uh, what's his name? Holder. Because why is Becky Patty mentioning Brad Holder? Why are there sticks on those girls? Why? Just there's so many questions. Why would Brad Holder be saying all the things about Pat Westfall and his crew? Like, have you ever thought about that and tried to reconcile it in your mind? If Brad Holder was a real big part of that with Westfall, then why would he be secretly telling his wife, I think Westfall and his crew did it. Be careful of them, blah, 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 blah. Don't fuck with them. They're powerful, but got powerful friends, blah, 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 blah. There's something odd about all that. Well, now you see, you always know what to really look at by what these troll farms say and what these officials say when they come do their PR rounds. So now what Vito is doing, David Vito is trying to discredit Todd Click and the crew. Well, it makes a lot of fucking sense because why do you think they arrested Todd Click? They arrested Todd Click for the same reason that they killed Greg Ferenczi. So the fact that right now David Vito's trying to discredit Todd Click and those make me focus right back on Todd Click and them, and which is what the Frank's memorandum did. But see, it's funny that Baldwin in the Frank's memorandum didn't ask these questions. He didn't think to say, why is Brad Holder warning Amber Holder about Patrick Westfall if Brad Holder was involved? And I almost feel the same way about Holder as I feel about Logan. I think both of them have knowledge of what happened. They know what happened. They know who killed those girls explicitly. But they are protecting them just like Nicholas McClellan and company. I would almost be willing to bet that Holder and Logan were there and kind of witnessed some of it. It's really odd though, but like Andy has said about that Frank's memorandum, is the interesting thing about that is it's all documented, it's all sourced, it's footnoted. So there are things to look into. And remember, I've shown you about Josh Chrisman. Okay. I thought it was real odd. You had Elvis Fields working for Josh Chrisman. Josh Chrisman delivering pigs. And for years they've said, hey, Prof, a pig was delivered and there was a pig roast, a literal pig roast. There was a pig roast. A pig was delivered. And it made sense. It's like, well, fuck, if Elvis, that's how Elvis got involved in this, that he was part of delivering this pig with Josh Chrisman. Well, who's Josh Chrisman? Josh Chrisman was the head of the KKK in Indiana, who are white nationalists, just like the Vinlanders. Sounds like a bunch of these individuals have some commonalities. Meth dealing, Norse pagan white nationalist associations, gathering in the woods like a cult. So let's reverse engineer, if that's somewhat of the situation that happened, and if Brad Holder telling Amber Holder that Patrick Westphal has powerful friends that will protect him, if that's correct, then the question is why? Who are Westphal's powerful friends? And were there others involved who also have powerful friends? And who are those powerful friends? I mean, you would have to assume that the leader of the KKK in Indiana has powerful friends. I mean, come on, I fucking guarantee you, dude. I would guarantee you that the Vinlanders have powerful friends. So is this judge working to cover for the powerful friends, or is she working to cover for herself, or is she working because she's under duress? Like, why is this judge doing the things she's doing? I don't know. There's a lot of questions, not a lot of answers. But speaking of negligence, you got to ask yourself, with all the effort they made to run all of us off this case and the defense attorneys off this case, think about how they just back off of it for a minute and think about this. Think of how they literally tried to run everyone off this case. You guys ain't really thinking. Julie Melvin, Rick Snay, the Prof, Meow, Joe Lewis, Andy Baldwin, Brad Rosie. They have literally tried to run everyone off this case. Todd Click. Why would they do that? Remember, I did a show called The March 2024 Testimony of Officer Todd Click. I'd highly recommend those of you who haven't seen it, go watch that show. It's from a month ago. It's a live stream from a month ago. The March 2024 Testimony of Officer Todd Click. Because remember, it was a mere matter of weeks after that testimony that they set him up and went and pried around with his employer to find his former clients he had contact with to try to set him up and accumulate some dirt on him to arrest him, and they did. So let's see. You kill Greg Ferenczi, you arrest Todd Click, you try to arrest Baldwin and Rozzi, you threaten to kill Joe Lewis, Meow, Rick Snay, Prof, this one, that one, the other. You try to arrest the defense investigators. You try to arrest the defense attorneys. You try to arrest the YouTubers. No one seeing a pattern here? I ask you this. Well, and before I say that, remember, they also tried to hide the truth from all the defense attorneys. Remember, they tried to hide Todd Click. They tried to hide Greg Ferenczi. They tried to hide Kevin Murphy. They tried to hide Brad Holder, Patrick Westfall, and that whole crew. Remember, we just read that in the past couple episodes. Like Jerry Holman tried to hide all of this. They tried to hide the sticks on the girls. They tried to hide Odinism. Shit, they tried to hide Kelsey's hair being wrapped around that baby girl's finger, pulled out from the root. They tried to hide the geofencing. I mean, once you get to know the ins and out of this, doesn't it just sound incredible? The amount of effort that's gone into this. Like they've literally tried to kill, to hide, to arrest, to threaten, harass, dox everyone. What kind of murder of two little girls have you ever seen that on? It makes no sense. This is something bigger. And on top of all that, they've got an entire PR team that you don't even know about. YouTubers, Facebookers. Oh, Facebook is the most infested. But YouTube, I would say 2/3 of the YouTubes, all of the Facebook, 2/3 of the Reddit. Why? Over the murder of two little girls 7 years ago. It's got to be something else. It's just got to. There's no question. I mean, at this point, how much evidence do you have to see? There's something else going on here. Like I always say, kids get killed every day. You don't see this every day on everything. Kind of lost track of where I was going with all that, but I guess the point that I'd like to get across to newer viewers, is that in these past few months, I've done a lot of very important live streams. All right. As I've just recommended that show on Todd Click a month ago, it's got some very important discussion because it's not just about Todd Click that I discuss in there. I discuss about some of this. I did the show on Shank, okay, Kathy Shank, and then I made some community posts. I often recommend that you go and look at both community posts or the walls on both channels because on both channels I put different things, and I've shown you about Shank is the thing about Shank. It's highly questionable, highly questionable. I did a show called Other Actors, all about the Kokomo crew and the Vinlanders. And I think there's an intersection here that we're dealing with Kokomo crew and Vinlanders. It's a nexus. I did one on the three phones, talking about specifically how the FBI looks at geofencing and pings and all the differences, specifics of that. I've did a lot of great shows, okay? And so you can always go back and find some of that. And like I said, also on the community page, a lot of nice receipts posted on those community pages. So please do subscribe to both channels, or at least take a look at both channels. Please support the channel. If you're new here, I have Cash App tagged up above at the top of the live chat and on the About Me section. I love the Cash Apps and the Buy Me a Coffees that sometimes come in. They're nice to see. They're encouraging. Appreciate that. And hit the like as well. Yeah, it's been pretty exhausting. It's so hard for me to always read these states' filings. I just can't even handle reading the words of McClellan. I mean, absolutely infuriating. Okay, so please. Thank you, Mark Ellis. Please be aware that I never want to read McClellan's words. So I have no problem going through our defense filings. They're always interesting, always pretty believable, but that's where I'm getting back to. That's what I'm getting back to, I guess, is think about it. Where are the ethics? Where's the acknowledgement of reality? Regardless of how you're trying to snake around the issue, like, dude, come on, the headphone jack on that phone was activated, and then it was later deactivated, which means something was plugged into it, and later something was unplugged from it. And remember, there's a coincidence, or there's several layers of coincidence allegedly that they want us to believe. For instance, at the time that headphone jack is activated, it's milliseconds after the phone rings. The phone rings, bam, headphone jack. And then another coincidence, a mere 4 minutes later, the third phone leaves the geofencing. What are the odds of that? So 3 coincidences. So you want me to believe that the phone rings and milliseconds later, someone plugs in that headphone jack, or what they wanted you to believe is that the phone rings, then the phone magically gets dirt milliseconds later or water in it to activate the headphone jack. And then coincidentally and inaccurately, A third phone leaves the geofencing a few minutes later. Does that make sense? Or does it make sense that the phone rings while someone has it in their hand and they immediately, the second it starts ringing, they plug something into it and then they set it down and then they hurry up and get the F out of there. Maybe they thought that someone heard it ring and they were like, fuck, I got to get out of here. And they skedaddle on out of the geofencing. Okay. And then your prosecutor tried to lie to you and gaslight and say that there's something like a 5,000 foot radius or something like that to the accuracy of geofencing, which is a lie. Because like I just referenced, if you go back to my 3 phone show, I read through the FBI field guide on pings and geofencing and all that. And what you learn is that there are 3 resolutions depending on the modality that's being used to track the location of the phone. One is extremely accurate. The other one is within several yards. And the other one is within the 5,000 feet. So what McClellan did, he took the absolute worst resolution or modality and tried to put it across as if that's the modality that's being used to look at that phone at that time. It's inauthentic, or it's not genuine, or it's in bad faith, however you want to put it. It's a misrepresentation of reality or the truth. So how can this prosecutor feel good about not reflecting the truth in his life and in his work or his actions? How can you feel good about that? How can you sleep at night? Same with Doug Carter. Doug Carter, how can you sleep at night? Before I go to bed, I think of the family every night. On my deathbed, I'll be walking over hot shards of glass for Jerry Holman. How can you guys sleep at night? For real. I mean, basically, look, you had 0 evidence on Richard Allen. Let's be honest here. That's reflective of reality. Okay. 0 evidence on Richard Allen. For those of you new to the case, you may not realize that there's 0, but it ain't Richard Allen. It's not even all male. There's 0 DNA or blood or anything on him or at his house or in his vehicle. But you're supposed to believe he got in his vehicle covered in blood from head to toe like he just slaughtered a hog and drove home. 0 evidence on his phones, 0 evidence in his church search history, 0 evidence as far as weapons, 0 evidence as far as DNA, 0 evidence forensically, 0, 0, 0, 0, 0, 0, 0. All they have is some fabricated fantasy world story about a bullet. And anyone who knows ballistics will tell you himself. Anyone who knows ballistics will say that's absolutely junk science. There's absolutely no way. Absolutely. Look, I know guns. You know guns. Everyone knows guns. People who know guns know guns. Anyone knows guns at all whatsoever will tell you they fucking lied in court about that, or at least misrepresented the truth about guns in court. There's never a case when you have to fire a round to produce marks that match an extraction. It's factually impossible. But you have to know how guns work. And probably if you know guns means you've shot them a lot and you understand how they work and you have experience with them. I mean, there's so many instances in which it can be proven there's 0 evidence on Richard Allen. Yet, what they did, they made this very narrow pathway, which is a path directly at Richard Allen. And they excluded everything outside of that. And they took an innocent jury. Well, that's what we're supposed to believe. Okay, a well-meaning, naive, innocent jury. We're supposed to believe that they took these 12 people, put them in that box, and they said, look, this is everything just headed only, and this is a railway headed directly over, plowing over Richard Allen. and they excluded all the facts and truth that can be proven, and that is known, and that is exculpatory, and that is inculpatory towards other people. And they hid all that from the jury. They blindfolded the jury, and they led the jury down one single path, and where that jury felt guilty that they had to get justice for those two poor baby girls who are heroes, who are innocent little angels. Those bodies were found on Ron Logan's land. You could not mention Ron Logan. Those girls were catfished out there by Anthony Schott's account that very day. But you cannot mention Keegan Kline. The entire community around the Vinlanders was talking about the Vinlanders being involved in doing this. Relatives of the Kokomo crew were talking about their relatives being involved in doing this. Garrett Kurtz, Ashley Garth, Nick Edwards, Chris Mathis, and Sheena Cottrell were all talking about being involved in some way, or seeing a snuff film, or possessing it, or whatever. You could not talk about them. I mean, basically, the entire fucking community of Delphi have put themselves in this murder. Couldn't be talked about, though. But what you could talk about, Richard Allen. Why? Because he looks guilty. Because once he searched, what is a good horror movie? Let's look at his Google searches, because one of the retard troll farm PR team members, he was going on and on and on and on and about how you're gonna it's gonna be proven when you see his Google searches, it's gonna be proven that he killed those girls. Google searches, Insidious and other disturbing things to watch on Netflix. Okay, here's another one. Should I Die Now? Deeply disturbing, terrifying movies on Netflix. Texas elementary school shooting suspect. Most effed up thing to watch on Netflix right now. 65 best kidnapping and hostage movies made. Hold on. Sounds like Rick and his wife were trying to get some Netflix and chill. And we're like, yo, we should Google some fucked up shit to watch, some scary shit on TV. What do we Google? Fucked up shit to watch right now on Netflix. That's supposed to prove that that's the proof that he committed the Delphi murders of Abby and Libby. That and a fantasy world bullet. No, and Dan Dulein's word that he said he was there at a certain time. None of which can be proven. So you got all of that. And remember on top of that, 70 days of deleted law enforcement work. That means interrogations, interviews, reports, 70 days, the entire first week, and then another 60 whatever days, 64 days. That's 2 months. 2 months and a week deleted from the investigation. They won't account for whose interviews those were, what was said, what was the contents of those interviews, blah, 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 marathon footage, deleted, fingerprints possibly deleted, yeah, DNA evidence, no family's phone dumps, no searchers' phone dumps, delete. But there's nothing suspicious going on here? Oh, and I didn't mention that when Scrimmin and Libredo were temporarily in the defense position on this case because the insane judge had removed Baldwin and Rozzi over the leaks caused by the troll farm. They get off the case. Barbara McDonald asks Libredo, well, tell me about the Delphi murders, about Richard Allen, blah, blah. One of those girls were murdered. It's scary. And one was sacrificed. And yeah, it's scary. Well, we're supposed to believe that Andy Baldwin is just insane and just he came up with that out of thin air, pulled it out of his ass. It wasn't in Discovery. He was the only one who believed it because it's crazy. Well, I don't know. Libredo looked pretty fucking convinced. And I bet Greg Ferenczi was pretty convinced before the fucking blew his head off. I mean, there's so many points to hit on that it's like where it's never ending. Because we could still bring it all back all the way around and say, wait up, Diener signed that PCA? What? Diener wrote the safekeeping request for Lesenby and then he ruled on his own fucking what? And the entire time, you had Jody Williams talking to the YouTubers. He's guilty and we know it. And we hope he gets the worst penalty because he's guilty. He's a monster. We want him in Westville because that's where he belongs. I've shown those documents. Maybe I should show them again because I just love rubbing it in. Where's that prof? Oh, just right here. The judge is releasing some info next week, a considerable amount per my source. And Skip says, is this from Nick McClellan? Dippity doo? No, person who works for Judge Gull. What? Also, my source, whenever I say source, I'm talking about this person who works for Judge Gull. She's seen all the docs. She says Richard Allen is guilty as fuck. She's 100% sure and wants harsh punishment to happen to him. She was saying she hopes the judge keeps him in Westville because that's where he belongs. You know, my source, the one who works for the judge. I hope my judge source will get access to some documents. She said she would need approval from the judge to go in and look at the unredacted ones. Yeah, this is a YouTuber. So yeah, that was going on. Well before trial. More than a year before trial. Been going on the whole time. So let's see. You had Murder Sheet doing it. You had that guy doing it. You had other troll farm doing it. You had Greeno over at the courthouse. He had threatened to murder Richard Allen, Andy Baldwin, and me, and Noe, and others, and he's allowed in the courtroom. Oh, yeah, the cops want me here because they like what I do. I bet they do. Well, yeah, I had another YouTuber saying, oh, yeah, I got paid to do this. All that fucking terrorism I've been doing to the defense folks, I got paid. And even now, denial of FOIA request, blanket denial of all FOIA. Remember, trials are supposed to be public, but we don't want transparency in this case, so we're going to not allow cameras and only allow 5 defense people in here because we're going to make sure we get all the fucking bootlickers up at the front of the line and fill up this courtroom. Okay, trial's over. We'd like to see the evidence. No. Blanket denial of FOIAs. You ain't seeing shit. No. A man had to die for it, but feel lucky. Feel lucky if you've seen the crime scene photos, because that at least proves that there's sticks arranged in geometric patterns on the bodies with right angles. And the upside down L written on a tree. I wanted to talk about that also, by the way. You know what I thought about? What's Liberty's name start with? I was thinking about that in bed the other night. I thought, oh my God. Did they paint an L upside down on that tree? Because it was Liberty. But see, someone had to die for us to see that. And we get blanket FOIA denials. But they don't want this questioned. You're not allowed to question anything that happened, even though you've had zero transparency. You couldn't see the trial. You have to believe what was said. You have to believe what's going to be in those transcripts. You have to believe that evidence was presented. You have to believe what the evidence is, and you'll never see it. And they're so afraid of the truth being exposed that ever since sentencing, they've been sending out those PR fucking pieces. Oh, here comes Holman with some bullshit. Oh, here comes McLean with some bullshit. Oh, Vito with some bullshit. Here comes Harshman with some bullshit. Here comes Diener, Stacy Diener with the bullshit. One after the other. Boom, 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 boom. Bullshit. Blanket denial. You ain't getting no FOIAs for this evidence. I'm surprised if you get transcripts. I mean, the troll farm's starting to get them. How many thousands they had to pay? And why is this a money laundering opera? Why are we talking about millions of dollars? You got millions of dollars to the historic trails operation, millions of dollars to the ballpark, millions of dollars to the prosecutor office, and now you got hundreds of thousands of dollars to the courts for transcripts for this 2 fucking years of transcripts. All the YouTubers throwing money at these transcripts. Boom, 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 boom. Thousands of dollars, thousands upon thousands upon thousands upon thousands of dollars. And every year, there's the Abby Libby bike ride. $30 a pop or whatever. Thousands of bikers, $30 a pop. Oh, let's see. 1,000 bikers at $30, that's $30,000. Well, if it's 2,000, that's $60,000. Well, it's 3,000. That's $90,000 a year in bike rides. Sorry, bro. Sorry, y'all. It's just ugly. It's ugly. And like I said, if the bloodlust from these people was about the memory of Abby and Libby, do you think this is what Abby and Libby would have wanted? Think now. Think now. Look at all that's going on. All right. All the controversy, all the unrest, the hate, the harassment still is ongoing. I mean, I got harassment this morning and last night. It's never ending. Every day, there's several live streams screaming about this injustice all over Twitter. Twitter is just full of it. It's if you go to Twitter, you're going to see so much noise about this injustice. Arguing on Facebook, arguing on Reddit, all over, just controversy, unrest, sadness, anger, threats, harassment. Do you think that's what those two little girls would have wanted over their deaths? Is this justice? Mm-mm. Rushing the justice, the wrong justice, with a complete lack of transparency, a railroading, shoving it up the ass of the public in the name of those girls. It's wrong. It's not justice. True justice would have been finding the evidence, getting it all together, making it unquestionable, like ultimately making it convincing, saying, look, we have evidence that these guys killed these girls, and then presenting it and being transparent the entire time, every step of the way, showing the public. Remember how people give advice? They say, you have to show the people. You can say all you want. You can talk, but you show the people. If you love someone, you show them you love them. The old folks used to say, deeds, not words. The sad thing here is there will never be justice for those girls. No one will ever be happy with. There will never be rest for those girls as long as this is the state of where things are. Because people know it's not right. People know it's not right. And the only way you're going to convince people that anything is right is you show them that the right things are done. You don't show negligence. You don't show bad faith, malfeasance, and lies, and obscuring, and all the shit that the state of Indiana has done, including this fucking right here. This state's, I guess, where I'm getting at is this right here is just an example. This fucking state's response to motion to correct error, the subject of our show. This right here ain't the way to win the public's hearts and minds. If you want to win the hearts and minds of the public, you have to show them the truth, which means facts, not how you can wriggle around the fucking truth and manipulate the judge and the public and the jury and blah, 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 and twist the law and bend the law and make it your way. And like I said, be prepared. This judge is going to totally adhere to this and deny the motion to correct error, and it's all going to be shoved back in the fucking hole. And yeah. It's just sad, man. It's really, really, really sad. And I hate to have a moment when we do sad shows, but this is just fucking sad, man. The thing is, people came to love Abby and Libby because of all the publicity. I mean, bottom line, the public fell in love with those two little girls and with the idea of justice for those two little girls. And that's what people want. They want true justice for those two little girls. And like I said so many times, I'm not here for Rick Allen. Why would I give a fuck? I don't know Rick Allen. I never knew Rick Allen. He wasn't my friend before this. I don't know him now. Probably will never know him. I'm here for that reason, for those girls. But Rick Allen is now intertwined in all of this. He's become just as much a part of this now as those girls, which is unfortunate. It's never supposed to be that. But I mean, look, they got a problem on their hands because unless something is done to rectify the situation, this will never end. It will not. The public will continue to cry out about the injustice and for freeing Rick Allen and for finding the killers of these girls and for showing the truth to the people, no matter what it is. And I've said so many times, that's all I fucking demanded. No matter what it is, show the truth to the people. What are you afraid of? Look, if you didn't have a case on Rick Allen, you should never brought a case. That's where you fucked up. It's not the people's fault that you fucked up. And had it not been for those coerced confessions coming out in Westville, he'd be free man to fucking day. Whoops. But the thing is, ain't nobody going to stop talking about the way he was handled in Westville, the fact that he was put in there, the fact that he was guarded by Odinus, the fact that he was medicated, he was under a fucking psychological fucking breakdown and treated by an insane fucking Delphi murders bitch named Monica Waller. No one's ever going to fucking forget that or stop talking about it. No matter how long you let time. Oh, if we just wait 6 months, it'll all die down and we'll get away with it. But it ain't. And people are never going to overlook the family just going along with this. That's another thing. If they leave the family alone, the family, the family, the family, the family. Well, you should have fucking did it the right way. Because this way, people will not stop questioning the family. They will not stop questioning the prosecutor, not stop questioning law enforcement. They will not stop questioning the judge. It's over. This is where we are until you rectify the situation. So I guess this is the best I could do was addressing this state's response to the motion to correct error. I couldn't do any better because I can barely stand to read a word of that insane prosecutor. Anyway, please go ahead and hit the like for me on the way out of here. I want to especially thank Mark Ellis for the super chat. Thank you, Mark. Thank Amy for the super chat. Thank you, Amy. Thank you, Mino Dino, for the chocolate fund. A to Z for the membership. Mudbug for the membership gift to whoever got it, and Mudbug for the super sticker. Thank you, Tammy Martin, for the super chat, and Oklahoma Nana for the super chat. And Low Light Recovery gifted 5 prof memberships. I didn't even see that. But thank you for gifting memberships to our viewers, Low Light Recovery. I'm sure whoever got those will appreciate the hell out of them. And someone bought me a coffee. Thank you for buying the coffee to whoever bought it. I won't see it until I go log into my computer. But I got the text that someone bought a coffee. So thank you so much for the buying of the coffee. Buy me a coffee. And everyone on the replay, thank you for leaving comments below and hitting the like and all that. I'm sorry that I made myself sad. Kind of in the closing there, I made myself sad because I started thinking about how this is an injustice. Ultimately, I mean the bottom line, I guess, of the point that I was hitting at is this is an injustice. It's not justice for this Abby and Libby. It's an injustice, and that's sad because we care. We cared about justice for those girls, and it's fucking sad, man. I've said so many times how the day Richard Allen got arrested and it was announced, I jumped out of my bed with joy. I was so happy. Oh, someone's gotten arrested for Delphi murders. Can't believe it. They found Bridge Guy. But unfortunately, that didn't last too long. As soon as I read that damn PCA, you know when it started? When I read that damn PCA, that PCA was it was like it was disappointing, but it was also suspicious. It caused a lot of suspicions to arise, and I thought, oh no, this don't smell right. Sounds like they were hiding someone. I just kept wondering, who is the person in all black? I'll tell you what changed it. When I read that PCA, and I thought, who is the person in all black? Sounds like they're describing two people here, Rick Allen and someone dressed in all black. And I wondered, who the fuck is dressed in all black? I still want to know, who's the person dressed in all black? Anyway, that started a journey, and here we are. Here we are. Shit. I mean, we are so deep into this journey. I wonder how many shows. Let me look. It says I have 408 videos, which probably means we're about 390 live streams or more. Close to 400 live streams. It's been a lot because each one is 3 hours. So it's been a long ass journey. Um, but hey, we're almost up to 5,000 subs on the main channel. We're about 2,500 on the backup channel. A lot of people have joined in for the ride, and appreciate that. Appreciate that. And I know that none of us are really gonna change our minds until like something happens. I mean, these FOIA requests should be immediately filled. I think we deserve to see the evidence. I deserve to see the original video from Libby's phone immediately. I mean, bottom line, like why is that being hidden? That should have already been out in the public. Where is the fucking original video from the victim's phone? Why can't we see it? Oh, and in this show, I mean, shit, it's we're 3 hours in. I've forgotten. I haven't even mentioned yet the missing photo of Abby on the bridge, which is supposed to convince us that Abby was on that bridge alive and well, and that Libby was there too, taking the fucking picture. Where's that? Like, Can't even have the basics. Not even the basics. Show me the Harvest Store video. Why isn't that entire fucking footage online? Like all fucking 48 hours of it or whatever. Show me the entire 12th, the entire 13th, or the entire 13th and 14th. Like, would it have hurt to just put the entire fucking 48-hour time period of the Harvest Store video just right online, let the whole world see it? Let's see every vehicle that passes. Let's see the entire fucking Libby video off of her phone. Let the whole fucking thing, unedited, unredacted, just boom, as it is. But no. How about that alleged photo of the two girls in Kelsey's car, supposedly on the way to the trails that day? Why don't we see that? I'd love to see that. I want to see that alleged photo of the two fucking victims in the Kelsey's car on the way to the trails that day. That's supposed to prove that they were there, or prove that they were alive and well on that fucking day on the way to the fucking trails on the 13th. Show me that fucking photo. Why is any of that too much to ask for? You see, here's what they know. They know the minute that shit is released to the public will do what it do. They will break that shit down to the microscopic level. Every piece of metadata, every fucking pixel, it will be scrutinized. And that's why it's hidden. One thing the public's good at is analyzing this information, because look, we have all the resources at our disposal. I have forensic experts right now I can call. Say, hey, you take a look at this metadata for me. You analyze this for Photoshopery. We're all just waiting. We're waiting to go over this with a fine-tooth comb and see. Let's see. If you're confident in your evidence, let's see it. Let's see that. Let's prove that we are delusional. Prove that there's nothing to worry about, that everything's on the up and up. Just go ahead and prove it. Prove it to the world. Just put it out here. You're convinced that it's right. Show the world. Oh, look, a piece of shit. That's okay. I'm documenting your channel before I block the fuck out of you. You look like a retarded white supremacist. I'm sure you are. Then you're permanently gone, so enjoy fucking your cousin or your sister, whoever that is on your channel. Indiana inbreds in the house. All right. So, with that being said, we'll be out of here. But thanks everyone for being here, especially everyone in the live chat. Appreciate you for being here. Really do. It's been awesome. Hey, it's an early show tonight, so we're done. We're done at the time that I'd usually be starting, getting started. So pretty nice. Nice to do an early show. I know for many of you it's late already on the other side of the Atlantic, and So maybe you'll get some sleep tonight. I know I will. Uh, Here's what's going to happen. I'm doing dinner, I'm doing dessert, and I'm doing bed. I made my homemade ice cream. I don't know. Any of you guys are aware of the Cuisinart ice cream maker? It's pretty amazing. So every once in a while, me and the little prof, we get the heavy cream and the milk and whatever flavorings we want, and we turn on the ice cream maker. We mix it up, and voila! 25 minutes later, homemade ice cream. So we did that yesterday. So we have plenty left over for tonight. So that's what's up with me. I'm anxious for the homemade ice cream. There's nothing like it. Plus, we only put in what we want to consume. I'm not stuck with having to question what kind of guar gum or okay, and any other additives are in it. It's purely what I want it to be. So appreciate it. I just love you all. Again, please do me a favor and hit the like. And like I say, all of those of you who are new, be aware that all of these live streams that I've done in the past month or two, there's really good information in there. So if you want to, go catch up on it. Xanthem jizz. Yeah, exactly. Yeah. All of the weird shit, it's not in there. Oh, you want meth flavor like DELPHI. Well, that's the guy I just deleted. He probably wants cousin's vagina and meth flavored ice cream because he's from Delphi. He loves it. All right, so we're out of here. Sorry for the crudeness. Old lady, forgive me. I'm just a young guy. I'm just having fun here. All right, I'm out. Hug your kids, hug your wife, and your daddies, and all the brothers and whoever you love. Hug them. We'll see you later. And go support some other creators as well, okay? We're out of here. Peep out.